these are appeals in the matter of supporting Care Ltd from Prestwick Care and others and 17 State Government Department.
Yes, Mr. Southey.
My Lords, I appear for the appellant in the Prestwick Care matter, Prestwick Care, with my learned junior Mr. Selwood. Mr. Mangnall, King's Counsel, and Mr. Hill appear for the respondent Secretary of State in that matter. They also appear for the appellant Secretary of State in the supporting care matter. Mr. Malik, King's Counsel, and Mr. Khan appear for the respondent in that matter. Well, I don't think there are any preliminary matters. I know there were issues with papers. I hope they've all been resolved. So I think we're ready to go unless the court has any issues it wishes to raise.
Thank you very much.
Lord, turning then, obviously, I think you've got the timetable, and the agreed timetable has me going first as the appellant in the Prestwick Care matter, and that's in part because it's certainly anticipated that I'm obviously going to take the lead in relation to what's probably the common issue, which is the extent to which there is a duty to take account of impact. Before turning to what we say about the legal basis for that, can I just set out some issues of fact that are important, some of which are important to the that overarching issue, some of which are important to the arguments that are only raised in the Prestwick Care case. The first point is, and what I want to do is just identify some factual themes, really. The first point is, in relation to that there was, before the learned judge below, uncontested evidence of the negative impact that revocation of the sponsor licence, and probably in one sense more importantly, the consequential impact on the ability of the sponsor to use migrant workers would have on both the applicant, residents, and commissioners such as local authorities. And in the papers you've got, the core, or the key piece of evidence probably, or the most extensive piece of evidence, is in the second witness statement of Ms. Akora, who was at the time head of legal for the group of companies. That's in the supplementary bundle, page 188, it starts. And the relevant passage, she sets out in detail, in one sense, the position of the appellant on the various breaches. But at 206, the key passage really for these purposes starts at 206, paragraph 52. And having started by saying that, in her opinion, the appellant wasn't asked about impact, and I'll come on to that question of whether the appellant was asked about impact, not asked about impact or indeed rectification of the shortcomings, she sets out what the position is in relation to impact. And she points out how revocation would potentially would result in the loss of 200 staff members. She indicates that, well, before saying that, she says that the impact would be catastrophic. That loss of staff members, that comment about loss of staff members, is consistent with the policy, which I'm going to come to, which provides for revocation of immigration status once a sponsor licence is lost. She estimated that potentially 10 or close to 10 of the 16 care homes wouldn't be able to function safely. She explains the reason for that is because the employees are among the most senior. And she explains that the nature of the care means that the staff members need to be highly qualified. She explains why it's difficult to replace the staff members at short notice. And of course, that, and in particular, she points out the shortage of care workers in this context, or workers in this area. That's in the last sentence of paragraph 52. And of course, that is consistent with the fact that there is provision under the immigration rules for people to be admitted in this context. If it was thought that it was easy to recruit people in this area, clearly there wouldn't be an immigration rule permitting recruitment. She points also to the impact on the individual workers in terms of their family. That's at paragraph 53. But probably in one sense, or potentially in one sense, most importantly, she also talks about the potential impact on service users and how, in particular, and that can cause, that can have implications for life expectancy. She makes that point at 54. And that's supported, and I'll come on to it, by material that was an email that was obtained from Gateshead Council. And finally, she reports that she points to the impact on local authorities at paragraph 56. There is evidence, I'm not going to take you to it, to similar effect from Mr. Malhotra, Devinder Malhotra, which is at supplementary 184. One thing I should make clear, because looking at the papers over the weekend and last night, I'm not sure this is clearly identified. You have, at the request of the respondent, papers relating to a second judicial review within the bundle. You've seen those. At page 228, there is a witness statement from Mr. Malhotra, a second witness statement from Mr. Malhotra. I was slightly, when going back over the papers at the weekend, I was slightly concerned it hadn't been made clear. That was submitted in the second judicial review. It wasn't before Judge Kramer, and so I think that needs to be made clear. So that it's one of the reasons I haven't referred to that at this stage. I referred to this witness statement because I wanted to make that, and I thought it was important to make that clear. Now, I referred a moment ago to the concern about impact on staff. Page 80 of the supplementary bundle contains a document, or extract of a document, that we're going to need to go to on several occasions, which is the sponsored duty guidance. That starts at page 46. The critical page is at page 80. And that deals with the process, essentially, or the expectation in relation to sponsored workers who are already in the United Kingdom, and save where it is believed the worker was actively complicit in the reasons for revocation, and it's not suggested that was the case in this case. There is an expectation that leave will be shortened to 60 days. That's not happened in this case. The reasons for that are relatively complex. They started with the fact that an urgent order was obtained from Mr. Justice Bryan, which is in the papers at page 180 of the bundle. Since then, there have been various stages. I don't think we need to go into the detail of it, but the key thing is I have to recognise that revocation of status hasn't happened in any individual's case, certainly as far as I'm aware. Partly because of court orders, partly because of agreements reached informally with the Secretary of State. Going back to impact, the other major piece of evidence that we obviously rely on is at page 181 of the bundle, and that is an email from a man named Barry Norman, who is on his signature is described as the integrated strategic commissioning lead and quality assurance and commissioning Gateshead system for Gateshead Council, and he expresses, well, he identifies in this email the fact that Prestwick is a key provider. And that's obviously consistent with the evidence, and I'll come to that, that Prestwick is a large care home group. He identifies the acute shortage of care staff. He uses the language in sort of lengthy paragraph on page 181. He describes the impact potentially of removal of 200 staff, which is obviously what the evidence indicates may happen, as being devastating. And raises also the issue of potential impacts on loss of life. And that is a point he returns to at page 182. And obviously the implication of all of this is that Gateshead would struggle in relation to its duties. That email is important, we submit, for two reasons. Firstly, because ultimately the Secretary of State's evidence says it's aware, at least in general terms, of the sorts of concerns that are raised there. Hasn't in any way challenged that. It also goes to a concern raised by Judge Kramer, which is the extent to which impact can be evidenced. And clearly, any evidence regarding impact is future-looking, so that there will always be some uncertainty. But clearly, this indicates it is possible for a local authority, for example, to express views about impact, knowing the impact on its own local community. Now the second, so that's the first thing that we say. Firstly, we say, uncontested essentially, that the impact of withdrawal of a sponsor licence can well be, and in this case potentially will be, significant for the claimant, for the appellant, for its residents, for local authorities that rely on it. The second point we make, and the sort of overall theme, is that, and it goes to the procedural fairness arguments in this case, we do submit that the appellant wasn't asked essentially for evidence of impact. You've already seen the evidence of Ms. Kaur, about that. Can I take you, though, to put that in context, to give a bit more colour to that, to the suspension letter? And there's no dispute, obviously, that the procedure adopted in this context is there's an inspection, there is then a suspension letter, which is, to use sort of perhaps more old-fashioned terms that are common in immigration, it's effectively a minded to refuse type letter. It's saying we have concerns, we're going to suspend your licence while we investigate those concerns. This is your opportunity in one sense to respond. But it's important to understand the terms on which that response was invited. If you go to page 159 of the letter, of the supplementary panel, you see the passage headed next steps. And this follows a detailed account, essentially, of the issues that had been raised, the breaches of the sponsor guidance that were alleged. And you see, paragraph 51, we believe that the issues described above constitute a failure to comply with sponsored duties. 52, to give you the opportunity to explain the above issues before we begin revocation action, we have suspended your licence with immediate effect. That first sentence is important, given our arguments. It sets the context of what follows. It makes it clear that what is being sought is an explanation for the above issues. Consistent with that, the next sentence describes how you can make representations, including in response to this letter. What response is being invited? In our submission, when read with the first sentence, it is an explanation of the above issues. Or certainly, at the very least, it is reasonable to read it in that way. It then seeks evidence in the form of supporting documents, which, when read, I'm not going to take you back to it, when read in the context of the breaches, it is potentially relevant to the alleged breaches. Nowhere in that letter does it say you have an opportunity to explain impact. Nowhere in that letter does it say you can demonstrate that you've taken steps now to remedy the breaches. Now, my learned friend's argument is you should read that letter with the policy. And the policy, it's the same document I took you to earlier, the duties and compliance policy. And the relevant passage is page 77. And it's paragraph C9.10, C9.10, yeah, and C9.11. And that's where the policy describes the procedure adopted in this case. Now, we say, firstly, it is reasonable to read this policy in light of the letter, because the letter is the direct application of this policy. It is what triggers any thought on the part of the appellant. It's what triggers any thought on the part of the appellant about what they need to say, essentially. Para C 9.10 essentially records the opportunity to submit a written statement to respond, and that's a response to the investigation, consistent with the interpretation of the letter that I've argued a moment ago for. It then provides, you've got 20 days to respond, so again talking about response. And it says, this is your opportunity to seek a review of our decision and set out any mitigating arguments you believe to exist. That's followed by your response to us must be in writing and set out with any relevant supporting evidence which grounds you believe to be incorrect and why. That last few words is important because it again focuses on the reasoning in the letter, and it's about challenging the grounds for revocation. Now, our submission is, and I'm going to come on to the legal basis for this in a moment, and I have to say, having actually gone back several times to research this, we actually can't find any case law. We found one SIAC decision where Mr. Justice Chamberlain assumes essentially the question is whether the approach of the person who was given an opportunity to make representations was reasonable. We can't find any case law which deals with the issue of whether the request objectively sought the information or whether it's a subjective test subject to reasonableness. The only, as I say, Mr. Justice Chamberlain seems to have assumed in one case that it was that the question was a subjective test. I'm always very conscious of making a submission that says there is nothing because you don't know what you don't know. But we do submit that's a potential issue that arises in this case. But we do submit that mitigating effectively in this context has two possible meanings. Mitigating can mean something that effectively means that the particular allegations were not as serious as they might seem to be. Or mitigating can have a wider meaning in the sense that it might be used in, say, criminal law, and it can mean anything that means effectively you shouldn't take action in relation to us. But because it potentially has those two meanings, when read with the letter, at the very least, it is not unreasonable for the appellant to understand what they have to do is respond to the allegations. And that's all. Now I accept, and I think I need to draw your attention to this, in New Hope Care, which is in Bundle of Authorities, it's page 684.
When you refer to authorities,
Yes.
and this goes for all councils,
Yes.
is it possible to give us a volume number?
I hadn't realised you'd been provided with hard copies, so I don't know where the split is. I have a split in my bundle. My lord, that's my fault. I only understood it as being electronic bundles.
Yeah.
If you can tell me where the split is, I will certainly do that.
Bundle 2 starts at page 455 in my copy,
Well, that's remarkable because that's where my bundle 2 starts, having made it up myself.
and bundle 3 in my copy starts at 913.
My lord, that's very helpful, thank you, and I will stick to that.
We're in bundle 2 now.
We're in bundle 2, yes.
Right. Which page did you say?
684. Thank you. And it's a judgment of David Piesky, King's Counsel, sitting as a Deputy High Court judge. And it's in the context, he found that the procedure adopted, it was a slightly different procedure, and it was, and so there's no direct analogy that can be drawn with this case. He found that the procedure adopted was procedurally unfair, and one of the reasons for that, considering paragraph C 911, was that effectively what that paragraph invited was argument both about whether or not there had been a breach of the guidance and also whether or not the sanction, which was revocation of licence, was proportionate. So he appears to have found objectively that this does include matters like impact. We don't necessarily accept that's the case. We would submit, particularly when read with the decision letter, and he didn't have a decision letter because of the procedure adopted, particularly when read with the decision letter, that is not objectively correct. But in any event, the question he was asking himself was not what was the impact of this material on the person affected, what would they reasonably understand to be the case. What he was considering was essentially what were the sort of issues that the sponsor needed to be given an opportunity to address, looking objectively at the policy. Can I then go back to the procedure that was adopted? So I accept that the material that was before the decision, before the claimant, was the suspension letter with the passages I draw attention to. I should say, just in fairness, that the letter, albeit not referencing that particular paragraph, did make reference to the sponsor guidance as well. You've then got the sponsor guidance. The response of that, which is consistent with the evidence you've already seen, was a letter from the appellant at page 161, dated 22nd December 2022, saying it was in response essentially to the Secretary of State's letter. And the way that was structured, and you see this by reference to responses in red italics, is that essentially the allegations within the suspension letter were cut and paste into this letter, and then in italics and in red, responses were set out. And effectively all that was included within that letter were...
Mr. Lovely, we don't have it in red, but I think it's italics. Is it?
It's italics, yes. I wasn't sure whether you had it in red. I was going to say, the easy way of following that is, as you say, my lord, it's in italics.
Yep.
The decision letter that then followed at 316 of the core bundle, well, it starts in fact at 300. It was dated 3rd of February 2023. It again goes through the various allegations of breach. I'm not at this stage going to take you to those, but it goes through them. And the key passage really...
Sorry, could you give me the page number again?
Sorry, 300.
Thank you, sorry.
No, that's my fault. Page 316 is the key passage for these purposes. Paragraph 95. And this is important for other reasons. I know it starts with the sentence, we will always, emphasise the words always, taking into consideration the potential impact revocation may have on a sponsor. And consideration is always given to re-rating a sponsor licence to allow a sponsor to demonstrate full compliance with their duties. And re-rating, as I understand it, I'm sure I'll be corrected if this is wrong, effectively allows for a sponsor to continue with the licence so that it can continue to employ, but they don't necessarily have the right to actually issue any new certificates of sponsorship to new workers. So the employer is given a sort of grace period to get things in order. Para 96 says, we have considered the possibility of downgrading your licence and issuing you with an action plan. However, we will only downgrade a licence and issue an action plan where there is scope to rectify. And so their reliance is indicated, is placed on the absence of any opportunity to rectify. And obviously, a lot of the focus of this appeal is on impact, but we do make the point the letter that you've seen, the letter regarding suspension, didn't also ask for anything about rectification. What that, in summary, seems to be saying in paragraph 96 is you haven't put forward a good case, essentially, as to why there shouldn't be mandatory revocation. That's then followed by para 97, which says essentially you were in breach of mandatory grounds, and in light of that, downgrading isn't appropriate. That is a conclusion Millennium Friend relies heavily on. We submit it can't be given the weight Millennium Friend places on it, because it follows the two preceding paragraphs, which say matters like we will always consider potential impact. It's not surprising that it said in para 97 that the breach of the mandatory grounds mean downgrading is not appropriate due to seriousness, because in the context of this decision, clearly there'd been nothing said about impact and been nothing said about rectification. Now, one reason why in our submission it is particularly important that there is a fair opportunity to make representations is because in this context there is what's described, I think in policy as much as anything, as a cooling off period. What the cooling off period means, to be clear, and it's in the sponsor guidance as well, at page 81, C 10.16, page 81 of the supplementary bundle, C 10.16, is that for 12 months, a sponsor cannot reapply.
I'm sorry, which page are we on now?
Page 81 of the supplementary.
Sorry, I was in the call bundle.
No, it's
Which paragraph?
C 10.16. And the key point about that is that what that demonstrates is that from a sponsor's point of view, if they have their license revoked, the real potential consequences in the case are staff within 60 days losing their immigration status, employment having to be ceased, but them being unable to do anything for 12 months. Now, you've got within the papers from a second judicial review. We suggested that's not relevant. We can't see the relevance of it. But the one thing that demonstrates is that what happened subsequently in this case was that there was an attempt to make further representations about impact after the decision. And what the position of the Secretary of State was, you can't do this because there's this cooling off period. What you're effectively trying to do is make a fresh application. And that's one of the reasons why in our submission it's really important that the initial decision is correct, because it's not. I know my Lord Justice Singh in particular has delivered judgments on the potential difficulties making representations after a decision and persuading someone to change their mind. But in this case, one's in an even stronger position about sort of objecting to post-decision representations, because in fact the Secretary of State is saying we won't consider post-decision representations effectively because of this cooling off period. The third point is, although the Secretary of State's position in her skeleton argument in this case is not entirely consistent, it doesn't seem to be disputed, consistent with general principles of public law, that there is a residual discretion to permit a licence to continue despite the existence of breaches and indeed despite the existence of mandatory breaches of the licence conditions. That was the position of the Secretary of State in a judgment which is in the authorities bundle. Given time, and I need to make on, I won't take you to it, but it was a decision in Gold Care Homes, which is authorities 2.
That's Alison Foster, is it?
That's the Alison Foster case, yes. Para 61 of that.
Sorry, which page?
Page 851 of bundle 2 of the authorities.
And paragraph?
Paragraph 61.
Thank you very much.
That was is recorded in the judgment of His Honour Judge Kramer, paragraph 33, which is in the core bundle at para 140. And it's consistent with a feature of the sponsor guidance that I just want to emphasise. The guidance itself, and I made reference to this earlier, talks about there being mandatory grounds for revocation. And they are said to be set out in Annex C1, and they're in the supplementary bundle, page 83 onwards. And the language, though, is in one sense a little imprecise, it's probably reasonably clear what's intended, and it's reflected both in the body of the policy and then in Annex C1, where Annex C1 says, well, this annex sets out the circumstances in which we will revoke your licence.
Sorry, what page is this?
Sorry, supplementary
page 83.
Sorry, bundles, yes. It sets out, it says these are circumstances we will revoke your licence, but it then says we may suspend first while we consider the matter, suggesting a recognition there may be a degree of discretion. But the key point I want to make about these is that it contains quite a wide range of conduct. So reference A rather, you knowingly give false information. That obviously is the sort of situation where someone deliberately misleads, suggests bad faith, dishonesty. Pretty difficult to see how, in those circumstances, someone is going to be able to demonstrate they should be trusted. D, to give another example of some circumstances where it's pretty difficult to see how someone could potentially be permitted to continue with their licence, not hold accreditation. In those circumstances, presumably the company can't carry on the business it is intended to carry out. S, but compare those with the two mandatory breaches found in this case. S, the role undertaken by a worker you've sponsored does not match either the occupation code stated on the COS or the job description you've assigned to them. Now, in that context, that may be something that's accidental, relatively easy to remedy. It doesn't mean that the role, for example, isn't sufficiently senior to justify leave being granted under the immigration rules. And certainly, having fully investigated it, and I'll come on to the material that supports this, the position of the appellant in this case was we wrongly used a job description that was more demanding than we needed to, but actually we would have qualified under the rules anyway had we used the correct job description. So it's potentially relatively easy to remedy and does not necessarily suggest bad faith. Then para 87.
Page 87.
So page 87, yes. Ground AA, this was the other one, which is you pay a sponsored worker less than you've said. My lords may have picked up there's an issue in this case about whether or not there was actually a breach of this rule. His Honour Judge Kramer suggested some concern about whether in fact there was a breach of the rule. But in any event, we're not relying on that in light of... But in any event, the point about this is, this again doesn't necessarily mean a desire to flout immigration control, breach immigration control, because on looking at the terms of this requirement, for example, it may be that a sponsor is paying the same or more than the immigration rules require, and there's simply, for some reason, a distinction between what was put in the original application and what is then paid. And it may be, for example, that there'd be an oversight in notifying of the change. And the reason I make these points is that when looking at the extent to which impact needs to be considered, one can see that there are relatively minor breaches, breaches in particular that don't necessarily suggest bad faith on the part of the sponsor, ones that can potentially be rectified relatively quickly. And basically our submission is, in those circumstances, given that, there is the obligation potentially to consider impact. And that's the context in which one should consider the Secretary of State's arguments. The Secretary of State's skeleton points to, at paragraph 28, or argues essentially that mandatory breaches will result in revocation. We submit that isn't consistent with basic public law. It's also not consistent with the Secretary of State's own position, which is to accept that there is in fact a discretion. I drew attention to the passages of judgments where the Secretary of State accepts there is a discretion. What the Secretary of State seems particularly to highlight is the approach of the High Court in a case called Tendercare. I can't off the top of my head remember the name of the judge. It is in volume 3, page 1288, the relevant passage.
Sorry, which page?
1288. It's that's right. It's Richard Kimblin, King's Counsel, sitting as a deputy High Court judge. It starts at 1262, but the relevant passage, as I say, is 1288. Now, what the learned judge in that case indicates, firstly, paragraph 147, is that because the guidance expresses itself in mandatory terms, it is, to use his language, in the nature of a rule. He then, relying on that, and there is reference to a number of authorities, probably the most significant reasons I'm going to come to, and certainly the one the Secretary of State places weight on, is the judgment of the Supreme Court in, I think it's New London College. He then goes on at 152 to say this, and I have to say we've slightly struggled, this is relied on by my learned friend, but we've slightly struggled with this paragraph. The legal duties in respect of a mandatory decision to revoke are not a two-way street. For the legal reasons explained above, there is no obligation on the defendant to make reasoned conclusions on a claimant's discretionary submissions on a mandatory breach. It may, however, in a particular case, be open to the defendant to decide for cogent reasons that he will not revoke. This, in my judgment, it would not be unlawful to take such a course. This, in my judgment, is the residual discretion which remains open to the defendant even in a mandatory case. Now, we submit in our submission that the way in which this operates is that certainly in circumstances where there is no dispute, there's a discretion, then that discretion has to be operated in accordance with public law. Once there's a discretion, public law applies. Now, public law is, of course, a flexible concept, depends on context, so the degree of fairness involved, for example, depends on context. But there's no sort of, the phrase in particular we've slightly struggled with is what's meant by there not being a two-way street. Because the implication seems to be that the Secretary of State has a discretion, but legal obligations that would normally exist in relation to a discretion don't apply. And in our submission, that can't be correct. Once there's a discretion, it has to be exercised in accordance with public law. Now, as I say, public law is flexible, it takes account of the context. Not every discretion not every public law duty applies in the same way. But fundamentally, we slightly struggle, which, as I say, is something my learned friend places weight on this idea of there not being a two-way street. I'm not entirely sure what that means. Now, I indicated, and you see this really from 140 onwards, that part of the approach in this case was heavily influenced by the judgment, particularly of Lord Sumption in New London College. I think my learned friend places weight on that. That is in the second authorities bundle at page 735. Well, the relevant passage is in the New London College, is in page 735. And to put that in context, the issue in New London College essentially was that my lords may remember that in Alvey, the Supreme Court had indicated that what had previously been immigration policies had to be immigration rules because the statute required practice to be, the relevant provisions of the Immigration Act required practice to be set out in the immigration rules. And that's what led to the immigration rules becoming as complicated as they are now. And what then was considered was that there was a challenge essentially arguing that the policies regarding sponsors, as a result, also had to be in the immigration rules. And that's the context of the language used in para 24, which refers to rules. And you'll see in that context that Lord Sumption starts in paragraph 24 by referring to section 3.2 of the Act, and that's a reference to the Immigration Act 1971, which is the provision that imposed the obligation to include immigration rules in the Act. Section 3.2 for the court's reference is set out at page 728 of the authorities bundle. It's para 6, bottom of the page, para 6 of the authority. What Lord Sumption then directs himself, unsurprisingly, because it's essentially a clear, well, it's absolutely clear from the terms of section 3.2, and indeed he quotes section 3.2 in the second sentence, is that simply because something can be categorised as a rule, and what he's clearly referring to in those circumstances is the sorts of things that potentially come within the immigration rules, it doesn't effectively, simply because something is a rule, it doesn't essentially become covered by section 3.2. What has to be covered by section 3.2 is essentially the regulation of entry. And he then adopts the definition of what relates to entry in Alvi. And in that context, he then says the mandatory criteria for responsible license are rules. But they're not rules essentially relating to entry. And that's really the key part of that judgment and the key paragraph in that judgment. The question that raises is, what does he mean by rules? Clearly what he's referring to is the sorts of things that potentially come within the immigration rules. But the immigration rules themselves, as is clear from the second sentence of paragraph 24, are concerned with practice. They're not concerned with, and the Lord will be very aware of this, there's plenty of state case law that says this, they are not statutory. And of course, in the immigration rules, there is freedom to depart from them, particularly in favour of the individual. So what in my submission, Lord Sumption is not doing in this paragraph is creating some sort of new and form of sort of policy guidance, something that has greater force than policy generally does. What he's specifically considering is whether the sorts of things were set out in policy, and clearly set out in policy, effectively came within the immigration rules. And that's not the issue in this case. So he's not, as I say, changing in any way the approach. And the basic reason, obviously, why there has to be a discretion is that nothing in primary legislation says essentially that the Secretary of State's in a position to bind themselves in relation to their discretion. Now, my learned friend also, he says, in the context of this issue of whether or not there is a discretion, in the same one sense, it appears not to be in dispute, that the current point-based system it places an emphasis on certainty. And he cites an authority, I'm not going to take you to it at this stage, but we'll need to go to it later for other reasons. He cites an authority, Rajan Null, as being authority for the proposition that the points-based system emphasises certainty. And that's correct. And the structure of the points-based system, in essence, is if you have the points, you're able to enter. But of course, that doesn't mean that there doesn't need to be compliant with general public law principles, discretion where what is being relied upon is policy. And this is the way in which the points-based system works, particularly where sponsors are involved, is it's a combination of rules which are clear, which give people points for various criteria being met, and guidance which has no greater status, it's not referred to, it doesn't have any statutory basis, it's there effectively because there is inevitably a degree of discretion still left, like who should be a sponsor. Now the fourth point, so our point 3 is that there clearly is, and as I say, I'm not entirely sure how much in dispute this is, a discretion, even in the context of mandatory breaches. And that, as I say, doesn't appear to be, we would submit, in dispute, although there is some uncertainty. The fourth point.
Are these still introductory points?
Yes, these are really my factual. Yes, I'm trying to get. I know I've gone to some law in the middle of these, my lord, but it's partly to make good the factual points.
And
really.
how many of them are there going to be?
I think 6. Right. Sorry, may have helped me. It may have helped if I'd done the classic advocate thing and saying I've got 6 points. But
yeah. So this is number 4.
Yes.
Right.
Point 4 is the Secretary of State, in fact, appeared willing, as I've already indicated, to consider impact. In support of that, I rely on the decision letter I've already taken you to. Probably more importantly, though...
Which letter?
Sorry?
Sorry, which letter?
The decision letter, the decision of
Decision letter, thank you.
Yes, and the reference again is page 316, paragraph 95.
Thank you.
Probably more importantly, because in one sense it adds greater detail to this, is the witness statement of Mr. McGee, who is a higher executive officer at UKVI. Starts at page 245, but the relevant passage starts at 250 of the supplementary bundle. Para 27 starts by stating we're aware of the impact that a sponsor revocation can have on a company. It might be worth emphasising the words company, because on the face of it, obviously we do point to wider impact, albeit the Secretary of State then goes on in their evidence to accept apparently an awareness of wider impact. The Secretary of State's position then effectively focuses on the impact on the company and the employees, and for example at paragraph 33 and 34 makes the point that employees can potentially find alternative work. Para 35 is where there is engagement with the issue of wider impact. And indicates that since October 2022, there has been engagement with the Department for Health and Social Care. And it's indicated that that is intended to identify risks to disruption of care. And that Secretary of State has, on occasion, applied discretion by, for example, pausing for a limited period visa cancellation to allow for continuity of care. We would say in relation to that 2 things. Firstly, that demonstrates a recognition that the license, a lot of the license can have an impact on care. Secondly, what it doesn't indicate is why, if it has an impact on care, discretion can't be exercised in appropriate cases, for example, in relation to the license, because it assumes, essentially, alternative sources of care are going to be relatively easy to arrange. It doesn't deal with the point that was made by Gateshead as well as by the claimant that a disruption of care can actually have an impact on service users. In this case, it says the Department of Health was made aware of the Prestwick Care's suspension, but nothing was received from the Department of Health or local authorities. What one doesn't have, given that local authorities are obviously key, is any indication, any certainty as to whether local authorities were in fact made aware of this. It then addresses the Gateshead email, and and doesn't challenge, far from it, what is said in Gateshead email, but says essentially that the Secretary of State was aware of essentially what was said in that email. It's very unclear how the Secretary of State can have been aware of that, because it's very specific about the particular impact of a care home group having the difficulties that Prestwick was saying it would experience in a particular local authority. It's not really explained how they're... But all of that suggests, nothing here suggests that impact wasn't regarded as relevant. Instead, the Secretary of State expressly says, to some extent, they've sought to take account of that. The fifth overarching point we would make is that the mandatory breaches, and given the time I'm going to focus on the mandatory breaches, the mandatory breaches were relatively easy to remedy. Didn't also necessarily suggest bad faith or anything on the part of the appellant. So, dealing with this as quickly as I can, the first one I probably need to address, probably because it's the most straightforward, is the issue about salaries. And if you go to page 166 of the supplementary bundle, you will see by the second hole punch, para 16, the passage that is being cut and paste from the decision letter, raising the issue of salaries. And the response then at the bottom of the page, essentially explaining that the idea was that there was a salary sacrifice scheme that staff could opt out of, but the idea was that you got more by way of pension if you remained in it. Now, the response of the Secretary of State in relation to that is in the core bundle at page 306. And it's really paragraphs 36 to 39. And the basic point made in that is that, and this is the criticism made by the Secretary of State, is the Secretary of State wasn't satisfied that although letters had been sent making it clear this was a voluntary scheme, etc., the Secretary of State wasn't satisfied that necessarily every employee had received those letters, and so that it had been properly informed. Now, the point about that is no suggestion that they were being paid less than required by the immigration rules, no suggestion that this scheme wasn't potentially advantageous, no suggestion that there wasn't an opt-out. The simple thing was, the concern was that staff needed to be informed of that. That is obviously a relatively easy thing we would submit to sort out. And that's why I won't take you to, again, to make progress, but the evidence of Ms. Cora, page 205, paragraph 50, she says these things are essentially capable of rectification relatively easily. And she also makes the point at paragraph 57 of her witness statement that advice had been sought about compliance with obligations.
Well, just give me the page number again for that reference.
Sorry, it's 205, paragraph 50 and 57.
Thank you.
Now, there is one other mandatory breach, and I need to address that, and it's perhaps slightly more complicated. The second mandatory breach identified at core 303 was, and you see it's essentially at para 20. And it is, you've not provided evidence that workers were performing jobs at the level listed on their cost being certificate of sponsorship. I'm sure the courts are well aware of that. The initial response to that, it's accepted, was inaccurate, and dealt with an issue that is not the fundamental issue in this case. It's now recognised, and it dealt with an issue that's primarily about the need potentially to train staff up before they were fully able to take on their roles. What ultimately, having fully investigated it, Cora was able to say, and she says this in her witness statement in these proceedings, was that erroneously, essentially for admin reasons, what had been provided was, and you see this supplementary bundle 189, page 9, para 9 and 10, what had been provided erroneously was job descriptions for a nurse. Now, the key point about that is, one, that's an administrative thing that's relatively easy to sort out. Two, it goes to the point I made previously about the rules. It doesn't suggest that the job description actually being used for these staff was one that didn't qualify under the immigration rules. So again, it was a relatively easy admin problem that could be corrected. And that's in the context, obviously, of a large, long-established business that had relied without problems on immigration migrant workers for a significant period of time, and which was, in our submission, unlikely to seek to undermine immigration control. It had bigger interests. It had interest in ensuring that its business continued. And fundamentally, when looking at this point about the extent to which it was possible to mitigate and remedy, probably more importantly, remedy the errors, all of these points, in one sense, as I say, we would submit towards the bottom end of the scale in relation to mandatory breaches, and as a result, that was part of the context in which impact needed to be considered. My Lord, Justice Singh, I realised my list was wrong. I only had 5 points, so I finished them. Sorry. Can I then turn to the legal arguments? And the first issue, and I recognise to some extent perhaps the division of the arguments is slightly artificial because it's closely linked to some of the other issues that follow, is the extent to which there is an obligation on the Secretary of State, or possibly, it may only matter if there's a power of the Secretary of State, to consider impact. But we would say there's an obligation to consider impact. Is
this your ground one?
This is ground one, yes. But I recognise to some extent, my Lord, that ground one, in practical terms, in terms of relief for the appellant, may link into the other grounds. That's all the only point I was making. Now, we say the obligation is there for a number of reasons. And the first of those is that there are statutory duties to provide care, such as those found in the Care Act, particularly those found in the Care Act, and that, as a result, is a factor that has to be considered. Now, I thought quite a lot about how we pleaded this, and also how we put this. And I think it's important that I'm clear about this, because for this reason. We pleaded this not as a direct Padfield claim, but relying on Padfield as a basis essentially for saying that there was a need to consider impact on care. Now, one of the reasons for doing that, and my learned friend Mr. Mankell yesterday helpfully identified the London Borough of Islington case as an example of that, is that to directly plead a Padfield claim, we recognise that there'd be a relatively high threshold to cross, and in particular, we'd have to demonstrate that local authorities were unable to comply with their duties. Now, we didn't plead it in that way. We pleaded it as being an indication, essentially, of why there was a need to consider impact on care. And in those circumstances, essentially, our point was that because the decision to suspend and then, well, the decision to revoke sponsor licenses had the potential to disrupt and potentially prevent provision of care. And because the Secretary of State might, in those circumstances, essentially be in breach of duties in relation to the provision of care, it was necessary to consider that impact. And that's really, in simple terms, the way in which we put the argument. And that's why, in one sense, we relied on one search, just to establish the fact that the Secretary of State could, in principle, have duties under Padfield. But as I say, the issue isn't so much whether there is an actual breach of Padfield, because that's never what has been pleaded. The issue is, because of the potential for a breach, is there a need to consider impact? And perhaps a better way of putting it, and this is closely overlapped, but it's a judgment that in fact wasn't available when we argued this before His Honour Judge Kramer, but it's a judgment we've relied on in this court, and it really in one sense encapsulates the principle. We have drawn attention to a judgment of Mr. Justice Chamberlain in ECPAT.
Where's that?
It's at volume 1 of the Authorities Bundle, page 406. And the context of this, and I did wonder this morning whether I should have brought the second judgment in this case. This was a piece of litigation which I don't know whether my lord is aware of, that arose from the use of hotels to accommodate unaccompanied asylum-seeking children. And it was complex litigation, involved a number of hearings, partly because Mr. Justice Chamberlain ultimately relied on the new provisions about which allow for the suspension of orders to actually more directly supervise the enforcement of his judgments in this case. But it was also complex because there were three judicial review claims. This is the judgment on part of those three claims. The primary claim was brought by a children's rights charity, ECPAT, who were arguing essentially that both Kent and the Secretary of State were in breach of their duties because hotels were being used, Kent being the local authority that had responsibility under the Children Act. Kent then judicially reviewed the Secretary of State, saying, because you're not providing us with the support we need, we can't comply with our duties. And so Kent's position always was, throughout this litigation, that they were in breach of their obligations, but they couldn't comply with those obligations, and they needed the assistance of the Secretary of State. And there was then a second judicial review where it's in fact held the Secretary of State was acting unlawfully because of the approach the Secretary of State had adopted. I did wonder if I should have brought that judgment. The reason I haven't, in some senses, is that ultimately that didn't depend on this principle that we've identified in para 206. It was resolved on the basis that the Secretary of State was accepting an obligation to assist Kent, but actually hadn't performed it in a lawful manner. So that's why I didn't bring that judgment. We can provide it tomorrow if it would assist. But the key principle that we picked up, which is in one sense a better expression of the principle we were really seeking to rely on by making reference to Padfield, is at the end of para 206. It's the last sentence, which is that if one local authority is to comply...
Should we just have paragraph 206?
Para 206, yes, page 406. It's the last sentence.
You say that encapsulates the principle you rely on?
Yes, exactly, my lord. It's that because we're in a situation which, on undisputed evidence, the provision of care is facilitated by the use of migrant labour. In those circumstances, it is important that the Secretary of State exercising statutory duties takes account of that. And that's really the point. We've always indicated that it's not our, despite what is said in the judgment, our point is not that provision of care is a trump card, it trumps immigration control. It's simply that because Parliament has obviously indicated the importance of care by imposing duties, decision makers have to be aware of that duty and take account of it if they exercise other functions that potentially impact on that. Now, my Lord, Mr. Justice Chamberlain, to be fair, in ECPAT doesn't cite any authority for that proposition. I've not been able to find any authority that really, in some senses, deals with it in that way.
The proposition is the last sentence of 206. Yes?
Yes, the last sentence. Thank you. But, my Lord, in our submission, it's consistent with, in one sense, common sense and consistent with basic principles of law, because if Parliament has indicated it expects something to be done, which it will have done by imposing duties on a public authority, then it must be necessary for other public authorities essentially to consider the impact of their actions on the ability of a public authority to perform those obligations. My Lord, and that's what we understand Mr. Justice Chamberlain to be talking about there. Secondly, the second reason why we submit there is a need essentially to consider impact on the care sector is in our skeleton argument. We haven't produced the underlying material for this. We can if need be, but I'm not sure it's in dispute. We set out the background to the current immigration rules that allow care workers to enter the United Kingdom. And essentially, we submit the background to the immigration rules is it is recognised there is a need for care workers in the care sector. And obviously, that's consistent in one sense with the Secretary of State's evidence, and in particular the agreement with the email from Gateshead, which recognises the potential impact. And that's important again, because when one looks at what the Secretary of State is doing, the Secretary of State is essentially taking decisions, except not under the immigration rules, but about the application of the immigration rules. And if the purpose of the immigration rules, in part, we would say the immigration rules in this context have two purposes. One is to make sure that immigration control isn't abused, and so they restrict entry unless certain criteria are met. But by facilitating entry, if those criteria are met, they're also intended to ensure that there is necessary workers admitted to the United Kingdom, necessary workers in the context of care, and that suggests a recognition that the availability of migrant workers to the care sector potentially provides support for the care sector. And as I say, we set out the background in our skeleton argument at 8D. And the third point that we make is the evidence which has never been challenged is that there is a potential impact on if someone is required to move care on life expectancy. Material was cited in support of that in the evidence in Cora. That we submit basic principles, essentially not dependent on the European Convention, although recognised in the European Convention. That engages a fundamental right, the fundamental right to life. And it's another reason why impact potentially needs to be considered. Now, the approach of the judge in relation to this really is set out in the core bundle page 138 onwards. He deals with this resubmit in two places. Para 31 indicates he'd not been cited with language legislation he needed to construe. Two reasons for that. One is it was never disputed that there were duties on local authorities. Two, because of what I've said about Padfield, this isn't, to say this in one sense isn't, although we categorised it, we relied on Padfield, what we were trying to express was a slightly different concept, I accept. And it was about conflicting duties. It's really more ultimately probably more the ECPAC point. He then goes on to say that the scheme requires a high degree of trust, and that the argument, my argument essentially meant that the defendant could be compelled by demand for care homes to operate the system when trust had gone. That in one sense is not our point, certainly not our primary point. Our primary point is that there is a need to consider the impact of revocation of a sponsor licence on provision of care. And remember, in these circumstances, it will not necessarily be the case, given what I've already said about the sorts of requirements that are an issue, that there will be a loss of trust. The learned judge then went on to revisit this issue to some extent in the context of a consideration of the Tside duty, because he directed himself at 89 that Tside essentially didn't apply because the issues that had been raised about impact and the extent to which the breaches could be remedied were not relevant. You see that para 89 is the first sentence is the description of the argument. Para 91 is where he then says, well, this argument fails because the matters were not relevant considerations. He then goes on to consider essentially one of the reasons why impact couldn't be considered, and he cites a judgment of Mr. Justice Nicol, as he then was, in Birds Hill Nursing Home at para 92 and 93, to conclude that he didn't think it was practical to gather evidence about impact. He also, in that context, raises an issue which I think I should probably just knock on the head to some extent, which is that you could get around this problem. He does this at the bottom of para 93 by saying you could get around this problem anyway by restructuring, essentially, the company. No suggestion, in fact, by the Secretary of State, I think, that you could get around this by restructuring the policy, by restructuring the company. I'll probably save that for reply if the Secretary of State's position changes, but the reason for that, quite simply, is that the policy guidance makes it clear, effectively, that if someone, which includes the owners of a company, has breached a sponsor licence in the previous 12 months, they can't be the owner of another company applying for a new sponsor licence, unsurprisingly. So you can't just sort of rebrand yourself. You can't just move the company from the care home from one company to another as a way of getting around that, which is unsurprising. But dealing with the more substantial point, which is the concerns in Bird Hill. Bird Hill is in the first authorities bundle at 315. And it's important to understand, firstly, what was an issue in that case. In issue in that case was, and you see this at para 37, was whether Article 8 was engaged. Not an issue that arises in this case. And what the learned judge was then clearly doing was looking at the evidence, applying the approach he's required to make of deciding for himself whether there's a breach of the convention, to see whether he thought Article 8 was engaged. And he was essentially, in our submission, making findings based on the evidence he had before him as to whether or not Article 8 was engaged. Certainly in our submission, what he was not doing was laying down some general rule about the impossibility of there being relevant evidence. He was expressing concerns about evidence which on the face of it seemed to be far more ambiguous and certainly without independent support. And one can see why on the facts he expressed concern. But the contrast here is, in this case, one does have independent support, we would say pretty detailed evidence about impact, and the Secretary of State essentially doesn't dispute it. So one thing one can say is, had the Secretary of State had the package of material the Secretary of State has now got, on the material that the court has, there's no reason to believe the Secretary of State would have said anything other than, I accept what you're saying about impact. Now, my learned friend says, in his skeleton argument, this issue of impact, he accepts was raised in the judicial review, but wasn't raised when the licence was revoked. And I've accepted that. I've said what the representations said. But that's why, to some extent, there's an obvious overlap between this ground and what follows in terms of both Tside and procedural fairness, and I accept that. I should say, though, that in that context, I think I've touched on this, and it's one of the reasons why I took you to the evidence which appeared to indicate a willingness to consider impact. Even if we're wrong that there is no legal obligation effectively to consider impact, we submit the evidence demonstrates the Secretary of State's willingness to consider impact, and the fairness issues would still arise. My learned friend also says we've never said it was irrational to revoke in light of impact. Of course, that's right, but that's not surprising, because we accept, in terms of the Secretary of State's decision making, the Secretary of State didn't have the material about impact.
Sorry, just for my note, can I just note, what was the proposition again? Can you just repeat what you just said?
The Secretary of State said, we've never challenged the rationality of the decision to revoke on the basis of impact. And I'm saying, well, that's not surprising, because we have to accept, on the material before the Secretary of State didn't have the material that we rely on now. And that's why we focused on the procedural arguments, because ultimately, even if we're right, there was an obligation to consider impact. If the Secretary of State had adopted a fair procedure and had sufficient material before them, then it would be very difficult to criticise the Secretary of State, because the Secretary of State didn't have the material I've taken you to, and I accept that, of course. That was material that was potentially available to the Secretary of State, but wasn't actually before the Secretary of State. Finally, my learned friend sets out a number of principles that are said to govern the role of the Secretary of State in this context in paragraphs 24 and 25 of his skeleton argument. He sets them out in response to the arguments about impact. And what, and those arguments, as I say, are they set out a number of principles that I think basically are not in dispute. Our point about them primarily is, well, we make 2 points really about them. Firstly, what they're concerned with primarily is essentially the extent to which the Secretary of State is entitled essentially to find breaches of sponsor guidance, and the approach the Secretary of State must...
I'm sorry, Mr. Southey, which paragraphs of
of the skeleton are you now addressing?
24 and 25 of my learned friend's skeleton argument, which I think is core bundle. If the pagination on the version I've taken out of is right, I think it's pages 74 and 75 of the core bundle.
Thank you.
Yes.
What in summary we would say is, firstly, what these principles demonstrate, perhaps unsurprisingly, in terms of the context of this case, is that, for example, the Secretary of State would certainly have a broad discretion as to what weight to give to impact, but that doesn't mean impact can be ignored. None of these principles undermine our basic starting block. They don't undermine the principle that essentially there is a discretion. As I say, I'm not sure that's in dispute. And they don't undermine the principle that we've indicated, or the other matters we've identified, which is that firstly, impact may be easy to remedy, and that, breaches may be easy to remedy, and they don't undermine the arguments essentially that impact is relevant partly because of the impact, primarily because of the impact it has on compliance with other statutory duties. What they're primarily concerned with is the recognition of two things, which we would submit are not inconsistent with what I've just said. Firstly, that where someone brings an unreasonableness challenge, it's a high threshold to cross in this context because obviously there is quite a lot of policy there are quite significant policy matters for the Secretary of State to consider. And secondly, as I say, ultimately the Secretary of State is entitled to give significant weight to immigration control, and we don't dispute that either. Now, the other arguments, the other grounds that follow from this, may, we accept, depend on the issue of impact. The Tside one being the most obvious. Because obviously if impact isn't a matter that the Secretary of State is required to consider, it's very difficult to see why the Secretary of State should gather information about it, which is essentially the approach adopted by His Honour Judge Kramer. That doesn't necessarily mean that they all fail if the primary point we make about impact is wrong. One reason why they don't necessarily fail is because it goes back to the point I made before, which is that the Secretary of State appears willing to consider impact if, in relation to the procedural fairness point, if the Secretary of State is willing to consider impact, then it must be still open to us, we would submit, to argue the Secretary of State must make that clear. It can't then, in their decision, say, well, you haven't put forward anything in relation with that.
I'm sorry, I missed the end of that because somebody was throwing some bottles.
Sorry,
some empties after a party. Forgive me. What was the last 5 or 6 words?
What I was saying was what the Secretary of State can't do is say, you didn't submit any evidence on impact if the Secretary of State hasn't given a fair opportunity to raise that issue.
It didn't stop you. If you wanted to, would there have been anything the Secretary of State said saying, I'm not going to take this into account?
Well, in one sense, one can always say anything one likes, because which would be...
So why didn't you?
Well, because they didn't understand that's what they were being asked for. That's what this... And procedural fairness in our submission, it can't be met, because in one sense it would be always an answer by saying, well, you could have always said these things. One needs to remember the Secretary of State sets a tight time limit and says, this is what I want to know, effectively.
Right.
And in those circumstances, it's not surprising, we would submit, that the company comes back and says, well, here's our answers to what you want to know. Now, in one sense, I was going to go on to sort of give an overview. In one sense, I'm still giving an overview about where we are with the sort of linked points here. Not the linked points, the further grounds. I'm going to go on to deal with Tside next because that's the order in which we've pleaded it, and we've pleaded it always in that order. Looking back, in one sense, there is actually a logic to dealing with Tside after the procedural grounds, because I sort of thought about this when preparing, because if there was a fair procedure, and we say it wasn't a fair procedure, then it becomes easier for the Secretary of State to say, well, actually, there's no Tside problem, because I gave people an opportunity to give me the information. They didn't take advantage of it. What more was I expected to do? And that's why, to some extent, I think logically, the way in which it's pleaded probably doesn't actually logically make sense. But I can deal with it in this order, and I hope it assists to deal with it in this order simply because that reflects the way in which it's always been argued, effectively.
Yes. So you finished with ground one.
Finished with ground one. There's nothing much more I can say about it.
No, that's fine. I just want to check where you are in your
Yes.
submission. So you finished with ground one. You're now addressing us on ground two.
Exactly, my lord.
Which is
Sorry.
in your skeleton argument from
Yes.
paragraph 22.
Yes.
Thank you.
Now, my learned friend, helpfully, again, looking at his skeleton argument, indicates in relation to Tside, give myself a reference to it, that there is probably not much in dispute between the parties in relation to the principles. And he cites Plantagenet and Alliance. We cite, I think, separate subsequent judgment applying Plantagenet and Alliance. And I agree.
Which one do you cite? Just remind me.
I think we cite Baligieri, I think.
Yes.
Yeah.
Yeah. Well, that gives the imprimatur of this court
Yes.
to Plantagenet Alliance.
Yes.
And it's, of course, binding on this court.
Yes, yes. And so nobody's disputed. I one sense was just drawing attention to my learned friend's submissions about it on the basis that it makes it clear there's no real dispute between the parties in relation to this, rather than my own skeleton argument. But my lord's right. Baligieri, albeit Plantagenet and Alliance, was obviously a pretty powerful divisional court to some extent. But it's correct to say that the binding authority is Baligieri. So, yes.
So no dispute as to principle. So
No.
what is your what's the problem with what's happened here?
Well, what we would say is, starting from the point about that in one sense, principle 4 in Plantagenet Alliance, which is the court should establish what material was before the decision maker and whether any reasonable counsel, to use the language of Plantagenet Alliance, could have been satisfied, essentially, that the inquiries were sufficient. That's an important starting point in our case, because if one thinks about the material in this case, and in particular one thinks about the witness statement of Mr. McGee, Mr. McGee says pretty clearly, certainly read in the context of this litigation, impact is potentially relevant. He doesn't use that language, but that's the implication of what he's saying. He says then, and this is the way my learned friend puts it, I think, hopefully, well, paraphrasing what he says, but hopefully not inappropriately, my learned friend says he was aware in general terms, essentially, of impact. But he doesn't, in our submission, indicate the route by which impact could be specifically assessed. And I'm going to come on to this because it may be relevant for other issues as well. In our submission, of course, in one sense, whenever a sponsor loses their sponsor license, that will have an impact on the business because it will restrict the extent to which they are able to recruit overseas. It restricts their pool of potential applicants for a post. And they are likely, because they've had a sponsor licensing before, the business is likely to have built its business model to some extent on recruiting overseas. However, that doesn't mean impact is identical. Firstly, it may depend on the sector. It's why earlier I drew attention in particular to the fact that in the care sector, there are statutory duties essentially to provide care. That may be different to other sectors. Secondly, and probably in one sense more importantly, what, for example, the Gateshead email is pointing to is the fact that because Prestwick is a major regional provider of care, it was going to have an impact. Now, there's an obvious difference between preventing an employer who perhaps operates one relatively small care home recruiting overseas and preventing a major group that is a major provider of care in one region recruiting overseas. The latter is more likely to impact on statutory duties, and that's why we say it's not sufficient to say in general terms we're aware of the impact. One needs to consider the particular impact. And if, and this is where I point to the overlap with the grounds that follow about fairness, if we are right that the procedure was unfair, in those circumstances, the most obvious body to provide evidence of impact, which was the appellant, wasn't given a fair opportunity to comment on the specific impact. There was, on the evidence, contact with the Department of Health and Social Care, but there is no indication in that the particular local authorities, despite being key, were directly contacted. Responsibility essentially was left with the department. And certainly the Gateshead email implies that at least one local authority would have had something significant to say. Now, my learned friend, in his skeleton argument, relies on the judgment in New Hope Care, and that's Authorities Bundle 2, page 687, the relevant passage. Again, it's the judgment of Bejewski. Now, the passage my learned friend relies on is paragraph 127, and I'm going to come to that in a moment. But just to put this in context, at this point in the judgment, what the learned judge is doing, you see this from paragraph 122, is considering an issue that he accepts he probably doesn't actually need to consider because he's already found unfairness. And the issue about it was essentially very closely related to the issue in this case, which was the extent to which there was a need to consider impact. And you'll see at para 117, for example, Mr. Malik, King's Counsel, relied in that case, unsurprisingly, on supporting care. And the learned judge said at para 127 that there was, in his opinion, a meaningful distinction between being required to stand back from the detail of an analysis of misconduct asks whether the ultimate sanction is proportionate, bearing in mind the obvious seriousness of the decision and the sorts of built-in consequences, and proactively being required to investigate and make precise findings about the particular likely impact on actual individuals. He emphasises that word actual. I emphasise that word actual for reasons we'll come to, who've been cared for by the claimant, or actual employees. He indicates, in my judgment, A may be required, B is not required for the reasons set out in cases including this case. Obviously, to the extent that's based on Prestwick, we say that's the wrong approach. But what we do say is, firstly, obviously, we endorse the approach that account needs to be taken of impact, and that potentially needs consideration, requires consideration to be given to it.
So what do you endorse?
The fact that by saying there is potentially a need to consider point A,
You endorse A.
it's effectively saying you need to consider impact. But more importantly, in one sense, the distinction or the sort of dichotomy drawn in that paragraph in our submission is a false one, in the sense that nobody is saying, in this case certainly, that one needs to go around in the context of a large care home group, such as Prestwick, and look at the impact on individual residents. That would be onerous and probably impossible. What we do say, however, is that what can be, indeed needs to be taken account of, and this is where the Tside duty potentially arises, is the sorts of matters that are raised by Ms. Kara and then in the Gateshead email. And they are specific to the provider because they look at things like the size of the provider, how dependent the provider is on migrant labour, potentially the sort of profile of people who are being cared for, what the role of the provider is within a particular local area. And they are relevant to impact for the reasons I already indicated, which is that there is an obvious distinction between a small provider with limited numbers of people who can relatively easily be rehoused, and a large provider who provides significant amounts of care within a local area. And so, going back, so we submit that New Hope Care doesn't provide the support, can't provide the support my learned friend seeks to place on it. And ultimately, the point here is that whether or not, in one sense, there is a legal obligation to consider impact, the Secretary of State accepts as a matter of fact that impact would be considered. Look at the decision letter in particular. The decision letter in particular says impact will be considered. Then, if the procedural arguments are correct, and I say if the procedural arguments are correct for obvious reasons, which is if they're wrong, then the Secretary of State was entitled effectively to rely on the absence of anything from the appellant. But if the procedural arguments are correct, the Secretary of State has no information before her, from the appellant, despite the appellant perhaps being in the best position, no evidence from local authorities. And that's in the context of what must have been obvious, which is this was a large provider. And so impact was potentially significant. Now, my learned friend, in response to that, also says, well, this is a mandatory breach, and so no requirement to assess impact. That goes back to why I started with the basic propositions I did, on the face of it, the Secretary of State in fact accepts a discretion, accepts that, to use the language of the decision letter, impact will always be considered. If that's the case, then the Secretary of State needs to ensure evidence about impact is properly before her. The Secretary of State also relies on the principle, essentially, that she's entitled to a light trigger. That, in our submission, apply a light trigger. That, in our submission, is concerned with the trigger, the threshold, rather, must be crossed before action can be taken. In one sense, that's not an issue in this case. We're saying, even once a sufficient breach has been identified, the Secretary of State accepts that impact is relevant. And in fact, the fact that a light trigger is applied in our submission potentially supports our arguments. And it supports our arguments because it means that the justification for action may be limited. And in those circumstances, the prospect of impact being sufficient to outweigh justification are going to be greater. And in those circumstances, it's particularly important that the Secretary of State is informed about potential impact. Now, the third ground, there's nothing more, I think, unless the court has questions for me, that I can say about the Thames side.
Right.
The third ground, and obviously, in one sense, it's strongly related to, or very closely related, rather, to ground 4. Because it's the context, in one sense, for ground 4, albeit we say whether or not we're right in relation to ground 3, we win in relation to ground 4. But the third ground relates to fairness, and in particular it relates to the issue of whether this was a context in which, to use my language, which in one sense I'm not sure is perfect, but I can't think of a better way of expressing this, a relatively high standard of procedural fairness was required, or whether perhaps a relatively relaxed obligation was imposed by public law. And the reason we say that is because I don't think there's any dispute between the parties that, in principle, procedural fairness is context specific. This point is being made in this particular context on occasion. I also don't think that, as far as I can see, there's any dispute between the parties as to the basic principles that apply.
I'm sorry?
As to the basic principles that apply.
Okay.
And as the court's probably very familiar now, indeed, my Lord Justice Singh, I think, has applied the principles, certainly in Baligeri. The basic starting point when looking at fairness is the judgment of Lord Reed in Osborne, which is in Authorities 2, the relevant page, and the relevant passages start at page 900. And there are a couple of points that need, several points that come out from that judgment. The first is, as is clear from the last 3 lines of on page 900, going over the page, the issue for a court, and this is one area in which obviously there is a distinction between Thameside and procedural fairness.
Yes.
The issue for the court is whether the procedure was fair.
Yes.
I should say, and I'll come back to why we say this is a case in a moment, that I'm not aware of any authority directly on point, albeit, in one sense, Osborne is an example of this. We say that because it's a question for the court, on appeal, it's a question for the court to decide for itself. It has all the evidence. It's not as though there's factual findings in dispute. The facts were, in fact, not in dispute before the judge. The question for the court, this court, is essentially whether the procedure is fair. And if there's any doubt about that, we cite in support of that, I'll come back to a recent decision in the Supreme Court. We would also say that in any event, there are errors in the approach of the judge, but that may not matter so much, given what I've just said. The second point, which is really in one sense why, no, in a very real sense, is our starting point when looking at the point we've just made about the point I've just made about how demanding effective the standards are in this context. The second point is, what are the purposes, essentially, of procedural fairness obligations? And they are set out by Lord Reid in para 66 to 71. And he identifies... I don't know where you are. I'm very sorry about that, my lord. I don't know why my watch suddenly... I thought I'd got it on silent. I don't know why it suddenly started speaking at me, but I hope it won't do it again. Dealing with procedural fairness, he identifies three objectives of procedural fairness, albeit I think two of them probably are pretty closely related. The first is, in para 67, it ensures better decisions. And that's one way, and you see that in the first paragraph of 67, the first sentence rather of 67. And that's the first way in which in our submission impact in particular is potentially relevant to fairness. If, as the undisputed evidence shows, revocation of a sponsor license can impact on the care of vulnerable, the people who may depend on continuation of care in order to maximise their life expectancy, that suggests it's particularly important that a decision is reliable. And that's particularly important in the context of this case, where, as you've seen, there isn't any possibility to go back after the decision and say, look, we misunderstood the procedure, or we now see that impact was relevant. Here's our evidence about impact. If impact is as significant as the evidence suggests, it suggests it is particularly important that there's an opportunity, a clear opportunity to raise that before the decision, because it's important the decision is right. The second, there are two other factors that are identified. The second is identified by Lord Reid in the second sentence of para 68. And that's described as the sense of injustice that would result if someone essentially who is significantly affected, whose rights are significantly affected, to put a full quote, by the decisions, is unable to essentially to make full representations. Slightly paraphrasing, but I hope appropriately. Now, I accept, obviously, in this context, that what's in issue in this case is not what can't be said to be the rights in perhaps a classic human rights sense of the claimant, of the appellant. There's no suggestion that their human rights have been involved, but clearly that sense of injustice arises if those impacted, and obviously those impacted are not simply the appellant, those impacted feel their interests have not been taken account of. And that, again, suggests it's important that information is sought about impact if impact is relevant, either because there's a legal obligation to consider impact or because the Secretary of State was willing to consider impact. The final factor is set out at para 71, and that's what's described as the rule of law. And what is said to be important in that context is that decision makers listen to people who have something to say so that their decisions effectively comply with the law. Now, I indicated in my submission there is an overlap between some of the value or some of the principles here, and this is an area where there is an overlap, because in our submission, essentially it links back to the first point that if you allow representations, if you ensure procedural fairness, the decision is more likely to be correct. What Lord Reed is saying here is one of the reasons why it's important the decision is correct is that if it's correct, it's more likely to be lawful, effectively. And so he's emphasising, in one sense, that importance. And for the reasons I've already indicated, in this context, that's important. Now, as I say, my learned friend doesn't dispute, I think it's paragraph 53 of his skeleton, Osborne applies. He simply says, you can't draw an effectively the standards aren't equivalent. Well, in one sense, that doesn't really help you, because we're not arguing here that there should be some sort of, obviously the issue in Osborne, stepping back a moment, the issue in Osborne was whether there was an obligation on the parole board to hold an oral hearing. We're not arguing for an oral hearing, so implicitly we're not seeking the same standards as apply in Osborne. What we are saying is that when those principles are applied, it is the standards need to be relatively high, and in particular, it's important that there is a clear opportunity to raise impact, given what I've already indicated. Now, my learned friend's primary authority that he relies on in response to that is Rajan, a decision, I think, of this court, Rajan Noel, which is in Authorities 3, 1078. And it's a judgment of Lord Justice Tomlinson. And what Lord Justice Tomlinson is addressing there in our submission is a different argument to the argument in this case. You see that from line 8, I think it is, of para 32, starting with the words, I was not, however, immediately impressed by the submission, that the supervision of this scheme by the Secretary of State attracts an enhanced standard of judicial scrutiny. He then refers to commercial impact. Obviously, we're not simply talking about commercial impact, but more importantly, in one sense, what Lord Justice Tomlinson rather is clearly addressing in that case is this an area where, perhaps to use language that is more commonly used in this case, the spectrum of reasonable responses is narrower, or is it one where there's a broad spectrum of reasonable responses? He's dealing with the sort of intensity of review question. He's not dealing with procedural fairness. Now, in one sense, the fact that intensity of review is relatively light touch, to use a shorthand, actually supports our arguments. And it supports our arguments because if the Secretary of State's decisions are going to be difficult to challenge on reasonableness grounds, that implies it's particularly important that the Secretary of State has all material before the Secretary of State. I mean, if there was a merits-based appeal from the Secretary of State's decision, it's probably easier for the Secretary of State to say, well, it's not so important that I have taken everything into account, because you'll have an opportunity to challenge that on appeal. That's not this case. This is a case, and is why, again, I emphasise the point about the absence of, or rather the presence of a cooling off period. The fact you can't make a fresh application for 12 months. If you have a situation where the Secretary of State's decision is subject to relatively limited review and cannot be, or is not going to be retaken for 12 months, that suggests, in our submission, going back to Osborne and the value of procedural fairness to ensuring the decision is the correct one, suggests a high standard of procedural fairness.
What I don't understand, I'm afraid, about this dispute, if there is a dispute,
Yeah.
is why metaphors like high start coming into it. Everyone accepts that what procedural fairness requires depends on the context.
Yes.
And you have a perfectly understandable argument, whether it's right or wrong,
Yeah.
perfectly understandable, that in the circumstances of this case, it was incumbent on the Secretary of State to invite representation
Yeah.
on the question of impact. Now, that's a good argument or it's a bad argument, but I'm afraid, speaking for myself, I don't understand why adding adjectives like heightened adds anything, or indeed illuminates the analysis.
Well, the reason why, and maybe it's the wrong approach for me, I don't know, but the reason why it is, we've always put it in that way, is it goes back to my Lord's point about context. What we were trying to express, and this may not be the best way of expressing it, is that taking the starting point that my Lord was putting to me, which is that context matters, this is a context in which it is particularly important that there is a proper opportunity to make representations. And that may be a better way of expressing it, but that's the fundamental the point that we were trying to make.
That's your fundamental.
That's our fundamental point, and it's a sort of short. And I may not have helped matters by using that language of high standard, but that's the fundamental concept I've been trying to get at, trying to sort of make. The fundamental point I've been trying to make is
that is understood. Thank
yes. Now, the second point that my learned friend pulls from or relies on in the judgment of Lord Justice Tomlinson in para 32 is essentially the last sentence. And that's the sentence the Secretary of State is the exercise the Secretary of State is engaged in involves no fundamental right of the appellant, but on the contrary, a right contingent upon adherence to the rules. Dividing those 2 points up, dealing first with the fact that what is in issue is something contingent on adherence to the rules. In our submission, in terms of the context of procedural fairness, which we accept is not what Lord Justice Tomlinson was dealing with, the fact that what's in issue depends on adherence to the rules doesn't undermine the need to have high standard. I keep saying, my Lord, if I use the shorthand, because I've now sort of mentally programmed myself to use that shorthand, I apologise. My Lord understands what I mean by that. If what's in issue is contingent on adherence to the rules, in our submission, it becomes important, particularly important in those circumstances, that one has an opportunity to put one's case as to why, in fact, any action in relation to failure to comply with the rules would be disproportionate.
Well, everything, Mr. Tside, depends on the context.
Sorry?
Everything depends on the context.
Everything depends on
A long
context.
time ago, this
Yeah.
court held that you have no right to be naturalised as a British citizen.
Yes.
But before the Secretary of State can refuse to exercise a discretion to naturalise you, if they have concerns about, for example, your honesty, they have to put that to you.
Absolutely, my lord.
So, speaking for myself, I'm not sure it gets us anywhere in the context of procedural fairness to say, well, you don't have a right to something.
Well, my lord, exactly. And Melinda is, in one sense, preemptively responding to a submission of my learned friend from his skeleton argument. I completely agree with that. And of course, in Osborne, we were talking about prisoners on licence. They didn't have a right to be on licence if they didn't comply with the rules. And that was an issue. Now, there are two authorities. I've said, my only friend points to authorities like Raj and Noel, and they don't assist because they're not dealing with procedural fairness. They're dealing with effectively the role of the court in what primarily would be a Wednesbury challenge, a challenge to the merits of the decision. As far as I'm aware, it goes back to the point I made before, which is it's always dangerous to talk about what you don't know. But as far as I'm aware, there are two authorities that directly, and they're both first instance decisions, directly address the issue of fairness in this context. The first of those is the Gold Care.
I'm so sorry to interrupt you, Mr. Southey. I know you'll bear in mind the agreed timetable. You're on ground 3 at the moment.
Yes, I'm pretty confident looking at my notes. I'm just about almost exactly on time, but I will try and...
We will expect you to finish by 1
Yes,
o'clock.
my lord, I understand that, and I've been monitoring progress, and we'll try and...
2 first instance decisions.
Perhaps, given my lord's remarks, I should summarise in one sense what we say and perhaps deal with them in response. The first of those is Gold Care Homes. That was a judgment which is, it's in the bundle of authorities. Its full name is Operation Holdings Trading as Gold Care Homes. It's a judgment of Alison Foster, Queen's Counsel, as she then was, where there was an argument about procedural fairness.
Sorry, what's the reference again?
The judgment starts at 833, bundle 2 of the authorities, yes.
Sorry, bundle 2833.
33.
Thank you much.
Now, the judgment is slightly difficult, in one sense difficult to follow, because it, as summarised, para 47, there was a sort of...
Is this I'm so sorry to interrupt you, but I'm very conscious of how limited your time is.
Yes, I was
Is
going
this a reply point?
Sorry?
Is this a reply point?
Maybe that's what I was going to say. All I'm going to say now, just to put down my marker, I wasn't going to actually take you to it, sorry.
Right.
I'm just giving the reference really for your own point. Our point is that ultimately all that is a decision on its facts that the procedure was fair.
You don't rely on it.
We don't rely on
Okay,
it.
let's see what Mr. Mackett says about
thank
it, and you can respond to
Yes.
it. Now, what's the other case?
The other case is the New Hope Care case. That we do rely on perhaps a little more. It's at 681.
Volume.
Volume 2. Volume 2. That was a case where there was a finding that a breach of common law fairness as well as, in fact, a breach of the guidance.
Right.
2 reasons, other than the fact, of course, it is a case where there was a finding of breach of common law fairness. Two reasons. Firstly, David Piewski, again in his judgment, at para 100 Roman 1, makes the point that procedural fairness was the opportunity to respond. It's at its highest where there are serious concerns. We submit that fits with the basic point we make about Osborne, which is if the impact is serious, it's important that there's a very clear opportunity to respond. Secondly, linked to that, when he then goes to common law at para 105, he makes the point that, in fact, common law right to be heard is particularly important where there's been a litany of failures. Again, we submit consistent with the Osborne point, because obviously there's been a litany of failures. The need to potentially persuade someone that they shouldn't exercise their powers to revoke becomes particularly important. Now, what I've just said is intended to effectively address, accepting the point my Lord put to me, that ultimately what matters in fairness terms is context, is intended to address the context. We essentially say in circumstances where the impact is potentially grave and where there's no appellate process, no opportunity to go back and say, please revisit your decision for a year, and that potentially has serious consequences, it is particularly important that there is a fair opportunity to respond. And that links in with the approach that was adopted, same bundle of authorities as an example, and there are a number of authorities which make this point. If one looks at the judgment in One Tree Estates, which is a judgment of Margaret Obi sitting as a Deputy High Court judge, para 36, page 830, she considered, as has been considered in other cases, this issue of residual discretion, but held, perhaps unsurprisingly, you couldn't criticise the approach of not exercising that discretion if you hadn't provided, to use her language, a particular reason to exercise it.
Is this a case about procedural fairness?
It's not, but it's about it. I'm putting in. This goes back to this issue of context. The point I'm making is, if you can only expect, which is unsurprising, the Secretary of State to exercise discretion in cases where you've put forward a case, it's important you put forward. I've also raised the issue of the cooling off period. Our point is, and this is one of the reasons why I was reasonably confident on time, because I've already addressed this, the suspension letter itself is, on the face of it, requiring a response addressing the breaches, not addressing wider issues such as the extent to which the decision would have an impact, not requiring representations about the extent to which errors can be corrected. Made the submission about the policy, and all of that needs to be considered in light of the well-known principle. We've cited King as authority for it, but I don't think I need to take the court to it. I can't believe I need to take I don't think I need to take the court to it, which is, you need to know what you need to address, paraphrasing, if the opportunity to address those matters are fair. So if you need to know whether impact will be taken into account. And the third thing I want to emphasise in relation to that in this case, which is from the policy, and I made this point when looking at the opportunity to respond, is of course the policy also said these grounds are mandatory. So it's not clear on the face of it that the Secretary of State will take account of impact. Now, that's the context in which the issue I identified earlier arises. And as I say, I'm always very cautious about making submissions about there not being case law on something because you don't know what you don't know. But we've done a reasonable amount of work trying to identify this. And that is this issue of whether a fair opportunity should be assessed objectively, in the sense of looking at the objective meanings of the communications and the policy that was available to the appellant, or subjectively looking at their understanding. Now, I completely accept, because it would be potentially a recipe for chaos, that a subjective, unreasonable reading of the policy and correspondence cannot, it would be very difficult to see how that founds an argument about procedural fairness. Because it would undermine the ability, essentially, of public authorities to take decisions if all you needed to challenge it was to come along and say, well, I didn't understand this letter, which was clear, unambiguous, whatever. It would be a recipe. So I accept there probably has to be some consideration of whether the understanding of what was said in terms of an opportunity to make representations was reasonable. However, I also submit that if, on a reasonable reading of the communications, a decision maker, a person whose representations were sought, understood that what was being asked for was limited, then that's the context in which arguments about procedural fairness should be assessed. And the reason for that is because it goes back to that fundamental point I made a moment ago, which is you need to know what is in issue before you make representations, because you can only be expected to address those issues. In reality, responses are required reasonably quickly. No criticism of that, because decisions need to be, these are important issues, they need to be addressed relatively quickly. Resources need to be put into providing a response. And all of that suggests that the individual needs to understand what it is they're being asked about. In our submission, it can't be fair for, which is what we submit is the case in this case, for a public authority to say, we will consider something, in this case impact. We've given you an opportunity to make representations, but you didn't address impact. But we didn't, it was unclear, in fact, that we were giving you that opportunity.
Yes, well, that's the essence of your complaint under ground 3.
It is.
And I think we do understand it.
And my Lord, as I say, the only authority we've been able to find on it, I hope the court got it yesterday, which was the case of Berisha. It's a judgment of Justice Chamberlain in SIAC. And it doesn't, I have to accept, and it's why it's not.
I'm not sure we have got it.
We hand up copies. It certainly was emailed to the clerk.
It was emailed, but
Yeah.
I don't think I've seen it.
My Lord, can I?
Is it Palestine Solidarity?
No, that's an authority from London. It's a case called Berisha. It's a judgment.
We better have hard copies. We have hard copies of everything else.
Yes. We have hard copies. I'm just handing up.
Thank you very much. Right, with the passage.
And I accept it's not the most helpful, but it's the best we could find. It's paragraph 41 onwards. It's a decision of SIAC, but it's a decision of Mr. Justice Chamberlain. The Lord, I'm sure, is aware that SIAC, I'm not sure everyone's aware in the court, but SIAC is obviously a court of record because it's chaired by a High Court judge.
Yes, paragraph.
It's 41 onwards, but it's really the heading because it sets out the question that Mr. Justice Chamberlain set himself.
Yeah. Right. Thank you very much. That appears to be an objective test.
No, it's a subjective test because it's did Mr. Berisha reasonably understand.
Well, that's what I mean by objective.
Oh, my Lord, sorry.
It's like having reasonable grounds to suspect.
Yes.
It's not enough that the police officer did suspect. It has to be objectively a reasonable suspicion.
Yes. My Lord, the reason I took issue I think my submissions, I've identified in one sense 3 possible tests.
Yeah.
One is what I described as the objective test, which is what actually do these communications mean? He's not adopting that test. There is then the intermediate test, which is what we advocate for, which is was the understanding of the person affected a reasonable one. There is the third one, which is just what was the understanding of the individual, and we don't advocate for that because we recognise that that's a pretty unattractive position for us to advocate for.
That's very helpful. Thank you. So I'm very conscious. You've got 10 minutes.
My Lord, I'm almost there. I'm actually think I'll finish slightly before 10 minutes.
I see. Okay. So you're on ground 3, but actually you think you've covered the other grounds.
Well, my Lord, yes, in the sense that ground 3 is. I'm just looking to make sure I remembered correctly this. I think I should have made this clear. My Lord has criticised me for not adequately. I think we accepted because it didn't go to the issue. Sorry, I'll just to make sure that. We accepted ground 4 was initially open-mindedness. In our skeleton argument, in paragraph 2, the latest skeleton argument, the replacement skeleton argument, we accept that in terms of open-mindedness,
yes,
the issue of impact doesn't come into that. And so, although Lord Justice Arnold's order, in principle, reopened everything, we accepted that because of the way in which the application to reopen had been put,
yeah,
we couldn't see how we could properly argue ground 4,
right,
and so that's not addressed in the skeleton argument. And my Lord, that's my Lord, I hadn't realised that was in my Lord's mind. That's why I was being very comfortable at that time.
That's fine. So ground 4 is gone.
Yes.
And then ground 5 is notice of the issues raised.
Which is yes, and that links back to fairness. That's what we're effectively doing.
That's what you've just been covering.
Yeah, because what I did was effectively, partly because of the question my Lord had put to me, which was about whether I was right to sort of, in one sense, use this language of high fairness as a separate concept.
That's very helpful, Mr.
Yeah.
Tside. Can I just check with you, is there anything you wish to say on procedural fairness which you haven't already said?
My Lord, there is two things. One thing I need to address, and then also I just need to possibly address briefly, if I've got time, remedy, although our answer in relation to that is probably obvious. The one thing I haven't touched upon, my Lord, and I'm not sure to what extent it's in dispute, was the approach this court must adopt if, in relation to fairness, given obviously there are first instance findings. And I mentioned that in passing, and I said I would come back to it.
Well, you've made your position very clear. You say it's a question of law.
Yes.
And this court on appeal decides questions of law.
Yes. My Lord, that's...
If that's disputed by the other side, we'll hear those submissions.
My Lord, thank you. My Lord, just to make it clear, just because it may assist my learned friend, so it's no doubt, we gain support, we say, for that from the recent judgment of the Supreme Court in re-abortion services.
I'm not sure you do, but we don't necessarily need to have that debate now.
Oh, thank you, Lord.
That's not a case about procedural fairness. That's a case about proportionality. And moreover, it's a case where legislation was under challenge. And this court, more recently than abortion services, in a case called Dalton Project, has explained what the test is that we have to apply in proportionality cases. But I'm not sure that any of that is relevant to a case about procedural fairness.
Well, my Lord, the only reason we drew attention to that was because of what is said there about the true nature, part of the reasoning in relation to proportionality was the true nature of the test that the court had to, or the issues the court had to approach, certainly in most cases in relation to proportionality,
yes,
was it, on the basis of undisputed facts, it applied a question of law. And that's the analogy we draw. Yeah. We say that on the question of fairness, in a context like this, the facts aren't in dispute. You have the letters, you understand.
Well, I understand the submission.
Yes.
I'm not sure abortion services gets you there. That's all I'm saying.
My Lord, I accept it doesn't get us anywhere other than making that point.
Right.
That about the nature of what's in issue and what the implications that have. The final thing I should just say briefly about this is, were we wrong in relation to this? Obviously, we do say the judge erred, not least because he didn't give adequate weight to the context. And I accept, to some extent, that may be a criticism of me on the basis that, given what my Lord's put to me, it may be that I was using unhelpful shorthand, but still the fact of the matter is he didn't give adequate weight, we would say, to the context. Yes. And secondly, he placed excessive weight because really he focused on, and you see this at paragraph 46 of the judgment, he placed excessive reliance on the guidance.
Right.
My Lord, finally, given what my Lord said about response, I perhaps just one final thing I should just put down as a headline point, just so that it's clear what our position is. Obviously, we say Section 31(2)(a) of the Supreme Court Act, a Senior Courts Act rather, doesn't apply in this case. And
is the Secretary of State raising Section 31?
Yes.
Right.
Yes.
Right. Well, again, I would suggest that you deal with this in
Fine,
response.
my Lord. I'm quite happy to deal with it in response. Yes. My Lord, I think slightly ahead of time.
Can I just check if my lords have any questions? No, thank you.
Thank you, my Lord.
Is there anything else?
No, as I say, slightly ahead of time. I've covered everything.
Right.
Thank you.
Would 2 o'clock be sufficient?
Yes, my lord.
We look forward to hearing you then. Thank you.
All rise in favour.